You're listening to the Valley Current.
Hey, Wachtell, how have you been?
Fine, how are you?
Yeah, everything looks good. You got that beautiful piece of art behind you. It's gorgeous. So thank you for joining.
So, Jack, what do you think about this case? I have a big question for you.
I have to tell you that I knew that the Wachtell Rosen firm was extremely profitable. They are always 3 times larger in profits per partner and always 3 times or more larger in revenue per lawyer. And they're a small, relatively small firm. I mean, it's 89 or 90 partners and maybe like 170 maybe associates, like that, under 300 lawyers, roughly. And then they've got a lot of support staff, and maybe they do some billing of those people too. But I never understood that they actually received success fees that were 5 to 10 times the amount of their very high hourly fees. So the profit model is now revealed in ways that were probably not well understood before. I think most journals and magazines writing about them talk generally about, well, they get big retainers. They don't really have to do any work for the retainer. It boxes out their firm from going and being adverse to other companies, and sort of like allows a chessboard to be created among all these Fortune 500 companies. But maybe the real multiplier here is the multiplicative success fees. Of course, this one seems very off the chart. And that's what we're going to spend a few minutes talking about, because you're the expert on fiduciary duty, and they were the fiduciary of this company at the time that they sort of renegotiated, if you want to call it that, their fee agreement. So tell me what you think, and tell me what your question is.
Did you read their time and their billing records, the time hours?
I have to say, I scanned it and thought, I've never seen so many timekeepers on what is really, I mean, look, it was a simple breach of contract case. This is not rocket science. This is the wording of a contract. We've talked about it before in different podcasts. And I think we both predicted, that Musk was probably going to be held to this contract, or that he would have to pay some substantial damages in backing out. Right.
Their time records include $60,000 charges for Westlaw.
Wow.
A couple of multi-thousands, tens of thousands for Westlaw, which is crazy to me because I believe they have a subscription and don't have any special charges.
Right. Westlaw typically, for those who don't know, Westlaw typically charges you a monthly fee, and then it's an all-you-can-eat fee, but they do send you a bill that says this research was worth so much money. And I guess if your fee agreement says you can charge as though it's a retail price, but I have to tell you, a lot of judges will never allow that for class action cases. You know, I had a podcast with a class action lawyer that said, look, a judge was coming down hard on the view that contract labor should not be billed on some sort of retail basis. Contract labor is like a vendor that should be viewed as a cost. And of course, a lot of contract lawyers are being used by class action lawyers.
Right. Well, my big question to you on this case was, what's their defense?
Well,
I'm not particularly impressed with the breach of fiduciary duty theory.
Okay.
I understand, of course, that there's a fiduciary duty, but we'll just go to basics. The negotiation of the fee is not a fiduciary process because the parties are aware of adverse interests and negotiate them. However, in this case, as you pointed out, there was a negotiation in June of 2022, and then there was this modification in October. And at the time the modification took place, there's a big question as to whether that exemption from the fiduciary duty applies. So I I sort of smiled at that. Basically, these are just flagrant breaches of the rules of professional conduct, reasonable, unconscionable fees, grossly unconscionable fees here, overbilling in the first place, and entering into a new agreement on October 27th, when Musk had already agreed to close the deal on October 28th. That by itself should be enough to void the agreement, I feel. Have you done any reading on disgorgement in the case of unconscionable fees?
Yeah, I mean, we should talk a little bit about why the remedy in the prayer of the complaint. The complaint was filed in San Francisco Superior Court, state court. It doesn't have a local defendant. Wachtell is a New York firm with one office in New York City. Very beautiful offices, very beautiful building, lots of leasehold improvements. Obviously, they really believe in going in style. And I have to tell you, and I've been to that building, I've been to that office, I have to tell you, it's first class all the way. But they don't have a local California office, and they don't have a lawyer that's named that's in California. I don't even think they have a California lawyer per se. But the point is, there isn't a additional defendant that would bust up diversity. So they must be assuming that this case is going to get removed to federal court, in which case you might wonder, why aren't they actually in federal court to begin with? I don't really understand that. And I don't understand why some of the executives that approved this fee agreement were not named to at least prevent the diversity from existing for the purpose of removal. That said, to answer your question, I think their defense has to be that somehow they were giving up even more lucrative opportunities to work on other work during this critical period of time. But even that is somewhat diffused by the complaint, because the complaint said that they sought out the representation. They sent an email to one of the legal officers saying, we would love to be able to help you with this case.
Besides which, loss of opportunity might have applied from June 21st to October 28th. There might have been a loss of opportunity, but from October 27th to October 28th, no loss of opportunity. And frankly, from the end of August, Musk was already caving in. So there was no opportunity giving up in this case.
Well, I'm sort of talking about the opportunity to do work with lots of other companies.
That's what I'm talking about.
Yeah.
In other words, this case did not distract them from other cases once it calmed down. And it calmed down rather quickly. And it was certainly all calmed down by October 27th when they did the last day agreement.
Right.
I don't see how they're going to defend this, frankly. Your point about diversity jurisdiction is a good point. As I wrote you, I believe they chose not to seek compensatory damages to make sure that it remains an equitable case without a jury.
Okay, so you're saying they, in effect, want to cause an argument that there isn't any issue for a jury, an issue of law, an issue of fact. This is all about equitable relief, and it should be tried by a judge. But then why the choice to be in state court? Is the view state court judges will be more realistic about fees being within a certain range? Because I have to tell you, in San Francisco Superior Court, compared to San Francisco Federal Court, judges don't see fee petitions that are in the tens of millions of dollars in state court.
Right.
The class actions are smaller. The Federal Class Action Act almost assures that. Whereas in federal court, the federal judges do sometimes see big fee petitions, albeit this is a very short duration. The deal closed, according to the complaint, I think it's accurate, it closed in like April of 2022. And the
No. Musk's deal closed in April. Yeah. Right.
Right. And then the binding engagement agreement because of noises about backing out was signed in June of 2022. And the work was done or the deal was settled by October. So we're talking about June, July, August, September, October. We're talking like under 5 months.
Correct.
Right?
Correct. No, I see, by the way, if you go back to that page 38, you'll see that there's a stipulation to try it in the California courts, but they did say state or federal. So it wasn't required to be in state court. But why shouldn't it be in state court? I wonder.
Well, you're saying the stipulation that's in the fee agreement?
Yeah.
The fee agreement, I thought, had an arbitration clause in it. Did I misread that too?
No, there's also an arbitration clause. Let me go back to that. You can go down to page 38.
I'll page down.
Yeah.
So I'm at complaint exhibit 18, which is kind of the closing letter.
Yeah, no, we have to go back up to exhibit 2.
Yeah, let me get there. Because the exhibits do tell the story almost better than the text of the complaint. And if you're a sitting Superior Court judge, and typically, unless it's in the complex department of the Superior Court, it's a random play as to who gets it. And it could be multiple different judges that will get it, and we'll have to decide different things. Now, I don't think it's a complex case. This case, I don't think the Musk case I don't think the underlying case in Delaware was a complex case. I don't think this case is a complex case. In fact, I think in many ways, your point is spot on, which is this case could be tried on the pleadings.
Right.
It's all there in writing. There's not a lot of testimony that's going to amplify this story.
I agree.
Right?
I agree.
I mean,
I agree.
Even if
and I wonder what their defense is going to be.
Well, they got to put in a theme that they worked extremely hard for 4 or 5 months, not even 5 months.
Yeah, but they got $18 million for that.
It used to be the case that when you had a case that gave you $1 million worth of fees, you thought, wow, I'm sitting on top of the world. Now, of course, lawyers snicker at that and say, come on, it's got to be at least 10 million in fees. Now, there's a lot of billing records here that are in Exhibit 4, so this is going to take a while to get through.
No, it'll go there soon.
But now it's like there's a new high watermark, which is try to get to $100 million in fees in 5 months or less. That's like an average of $20 million a month.
Correct.
I mean, that's an amazing amount of billing, if you think about it. But of course, these firms are pulling in billions now in revenue. They're part of the $1 billion club. There's very few firms that bill revenues on a worldwide basis of more than $1 billion. There are a few that bill multiple billions of dollars, but they've got 4,000 or 5,000 lawyers spread out in, 50 different countries.
Yeah.
And, that's a lot of people. This is a relatively small firm, 300 lawyers at max, I think. Of course, now there's a lot of capital. They could hire a bunch of lawyers. They could open their own office in California and furnish it to the hilt just to defend this case. But your point is, why waste the money? Right.
Right.
I mean, this is one where you have to wonder, if you were a mediator, how do you try to mediate this without talking about the amount of money that gets returned or some other approach? And I don't know what the other approach is, because you'd have to come up with some creative approach that says to Musk, well, the money's going to come back, but it's going to be used for some pro bono purpose that somehow gets him.
Yeah.
Like, imagine that as a mediator, you could promote the idea of, why don't we deal with the homeless problem in San Francisco? So here I am as the person representing Wachtell. I'm not, but if I were, I would try to persuade Wachtell, how do you feel about peeling off about, 50 million and maybe dealing with the homeless problem in San Francisco, particularly around the Twitter offices?
Right.
In San Francisco, if I had the ear of Bill Savet, who was the lead partner who originated this book, hopefully he would be open to all the goodwill that would create. That would be quite a creative approach. But conceptually, I'm sure the firm is like, hey, we negotiated a deal. We worked really hard. We get a multiplier all the time. Okay, this was a pretty high multiplier, but it was a pretty good result. Had we taken the case on a contingent fee, we would have gotten at least 20%. That would have been $8.8 billion, but they didn't have it on a contingent fee. Maybe that was their huge mistake here. Maybe they should have negotiated a contingent fee of some sort. But I don't think the shareholders would have liked it.
Yeah. They could have done that. See, the fiduciary relationship morphs from the beginning to later on. So in the beginning, they could have negotiated a contingency fee, and they could even have negotiated an hourly component against the contingency fee. Pay us $10 million against 20% of whatever we recover if we win. They could have done that. That's not illegal or improper.
I mean, I have to laugh at some of these time entries that have 14 hours of time with one-word description, strategy.
Yeah, there's a lot of crap in this time detail, a lot of it. You're almost where we need to be.
It's almost arrogant to say, hey, you got a full day of my time. You really want me to put down what I did? There's so many things I did. It's called block billing. That was block billing of everything was under strategy. So this is a signature that was done by the senior director of legal,
Colangelo.
Karen Colangelo. She's got to be worried. So here we're going back to, in the event of any dispute between the parties, whether it results in proceedings in any court, in any jurisdiction or in any arbitration, the parties knowingly had the opportunity. Okay, so I'm reading the wrong place.
It's the next paragraph, the last preceding two paragraphs. There we are, A and B.
So controlling law, dispute resolution, waiver of jury trial. Of course, in California, jury trials are not waivable pre-dispute. That's a constitutional right that the California Supreme Court has made clear. So whoever wrote this agreement,
wait a minute, we can agree to arbitrate.
Well, we can agree to arbitrate. We can agree to arbitrate, but if there is some court proceeding of some type.
Oh, we can't waive the jury trial in the court proceeding.
That's right.
We can waive the court proceeding and.
But did they waive the court proceeding? Because it says, under the laws of the state of California, so you're right, I thought it was New York, and it says consent to personal exclusive jurisdiction and venue in the state and the federal courts located in San Francisco County. So
okay, now here's the jams part.
Right, notwithstanding the foregoing, except with respect to enforcing claims for injunctive or equitable relief, any dispute, claim, or controversy arising out of or relating in any way to this agreement or the interpretation, application, enforcement, breach, termination, or validity thereof, including blah, 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 collectively dispute, shall be determined by binding arbitration before one arbitrator. The arbitration shall be administered by JAMS, in accordance with JAMS comprehensive rules.
But this is equitable relief only, so that the arbitration clause doesn't kick in.
Well, is it equitable relief, right?
Absolutely.
I mean, is it equitable relief? That's the reason the prayer. That's the reason the prayer says equitable relief. They're saying we're waiving compensatory damages, right? But they've got a 17,200 claim, which would allow them attorney's fees. They've got a claim that is arguing that this is an unfair business practice. Now, maybe they're saying they want equitable relief on that too, right?
Right. In other words, they've crafted it so that it doesn't go to arbitration and doesn't go to a jury. That's what I believe the complaint was crafted to accomplish.
So you're saying that the art of the drafting of that complaint, sometimes called the artful pleading rule, is they are choosing to limit their remedies to whatever the judge in equity, thinking back to the old English version of the judge in equity, gets to decide exactly what is the fair and equitable relief, really without resort to a jury and without resort to you can almost argue without resort to what the law, the facts are, but we know the judge is going to take the facts into consideration and the law into consideration. And you're saying at the end of the day, that does traverse both the arbitration clause and the jury alternative that might theoretically, but maybe both parties wouldn't want a jury in a case like this, because it really does become kind of a crapshoot, particularly in San Francisco, where there are a lot of relatively poor people. That would be like $122,000 an hour for each billable hour, because that's what it computes to.
Right.
That's just over the top. And, you know, some of these hours are 14, 16 hours a day of billing. I mean,
Right.
That is not necessarily the most productive legal work that you're going to get over that period of time. So it's a single arbitrator if it went to arbitration, but they seem to be saying it doesn't go to arbitration. Now, the big question, is there a perfunctory motion to compel arbitration as a way to get a stay? Because there is a rule that automatically stays. Now, this rule was just extended by the Supreme Court as well, a recent case by the US Supreme Court, if it's a federal judge that's asked. So if they do a removal petition, or even if they don't, and they make a motion to compel arbitration on the view that, well, the pleading is artful, but the reality is this is a form of damages, and we want a judicial interpretation of that, then the benefit they get, if it is a benefit, I don't know if it would be, is everything gets stayed until an appellate court decides whether the arbitration clause means that arbitration should occur, which I take at some level, if a state court judge wants to be cute, a state court judge could grant the arbitration and say, well, I'll let you guys duke it out in arbitration, and maybe you'll settle the case there, maybe you won't. And if I'm wrong, you can go up on appeal from the arbitration decision, or you can come back to confirm the arbitration decision, and we can revisit it then. And the Court of Appeal and maybe the California Supreme Court, if it stays in state court, the Ninth Circuit, if it goes to the federal courts, can visit it all then. I mean, there's a really interesting advanced civil procedure class baked into this problem, right? In many ways.
I agree. I'm going to be curious to see how Wachtell responds to this complaint.
Well, I have to tell you, they must have a dozen associates of really serious vintage, and maybe a few partners as well, crawling all over this thing and probably saying to themselves, and this is where I come out in terms of the lesson, you know, what's that old saying, you know, pigs get slaughtered, or what's that old saying, you know, how does it go, that old saying that's out there?
I'm not sure what is it?
Well, it's like, you know, it's like you can only go so far, and then you'll get creamed by just going too far. And I got to believe if there's a lesson in the business of the practice of law by a business firm, this is a business law firm, had Wachtell gotten any advice from anyone in California about this fee agreement, and they said, what do you think? I think anyone in California would have said, if you want that success fee to have any traction at all, number one, you should lower your hourly rates and discount them significantly to say something like, number two, we're discounting our fee by, say, 50% of our rate for each hour. And you're going to give us 50% of the typical 33% fee, 17% of the outcome. But in our discretion, based on whether it takes more or less time, we will lower that 17% of what's a targeted 44 million, because, you know, 44 billion, because that would be like $8 billion, right? That would be, you know, $7-8 billion. We, in our discretion, would lower our fee if we get results this year without appellate practice, without trial practice, just a bunch of stuff that makes them look good. And then they would say, Your Honor, we could have argued for $7-8 billion based on the investment of time we made. We were on a partial contingency. We were at risk of waiving what would have amounted to several $1 million worth of fees. That was a negotiated deal, and get it signed off by outside counsel for Twitter. So there's another layer to this, right?
They should have done that. You know, yes, all that is right, and we'll wait and see what they actually end up doing. I don't like the contingency concept because they didn't make this deal until a week before Musk closed.
Right.
So
that's another big problem.
That's a huge problem.
Big problem here, because it looks like there really was never any risk.
Exactly.
There was never any risk. This was almost, and I'm not going to say it was, but I'm going to say someone will say this was a form of looting the company.
Absolutely.
This was a form of backing up the truck and saying, how much can we put on to effectively punish Musk for doing this? Because let's look at the side of this that really does play an ugly role, which is Twitter got a number of people had to be laid off because Twitter didn't have operating monies. And Musk declared that there could be a bankruptcy. So there's a very equitable story that can be told, albeit Musk is not the most equitable character to tell it.
What do you think about the unclean hands argument?
Well, it makes him, he's such such an amazing outlier guy. Some people think he might be from Mars. Maybe he's an alien. He's obviously had immense success. Today, by the way, he announced he started a new company that's called XAI. Brand new announcement today. Just today, he announced XAI is basically going to investigate big questions using AI, like, what really caused the creation of the world? Like, he's got some big ideas, as though, hey, I'm going to leave a mark on this world that gets me the Nobel Prize. That's almost the Mars shot that he has in mind here. I mean, he wants to eventually go to Mars. He's obviously planning that. But conceptually, he doesn't look great in San Francisco because he laid off a tremendous number of those Twitter people who really felt blindsided by what he did. He fired all the executives. Of course, now we probably know part of the reason. He felt they weren't acting as good fiduciaries. And
he didn't know about this until after the closing.
That's what people don't understand. When the business gets sold, all of the attorney-client confidential documents are freely available to the new executives who were originally adverse and couldn't see all that stuff.
Right.
So now that the Pandora box is open, of course, this makes Wachtell look awful in terms of other Fortune 500 companies that wonder, are they really acting as good fiduciaries? I mean, this is almost an existential moment for Wachtell. They would laugh at me saying that, I'm sure. If they want to come on the show to explain why they would laugh at me, I'm happy to have them. But conceptually, they look like robber barons. Right. And the business press is going to be all over them. Forbes, Fortune, the entire set of papers. I'm surprised they haven't yet. Bloomberg, FT, the rest, Wall Street Journal had a story, the New York Times had a story, Washington Post had a story, but they haven't really dug into the billing, because now the Pandora's box is open. Look at what we do here. We put this case should have been done with maybe three partners and maybe maximum seven associates. That's a big team. 10 lawyers is a big team. Yeah. I mean, I've had teams that big, and I have to tell you, it's not easy to manage them. This team was like 70 people. Right. There's 70 timekeepers I counted at one point. Right. I mean, maybe some of them are, small billing, but I have to tell you, this is not what you do to try what is a relatively simple breach of contract case. And what I was looking for, you'll get a kick out of this, Raphael, because you and I talked about, I was looking in the time records to see if they spent any time doing a mock trial. Because to me, that's what would have really been worth knowing at the front end of the case, which is if this case goes in front of a Delaware jury. Now, maybe they didn't expect it to be a Delaware jury and they didn't expect it to be a jury at all. But even a group of Delaware retired judges would be a good mock trial, if you ask me. And I didn't see anything that suggested they did that. Now, I could be wrong. It might be hidden somewhere in the building. They had a $2 million or $2.5 million expert witness bill for Cornerstone, which seemed like a lot of money, right? I don't know.
I mean, this was, to me, if you read this case, maybe you vote that law firms should be illegal. I felt that way for a long time.
Well, remember, business to business law firm transactions are typically viewed as caveat emptor. Everyone is sophisticated, everyone negotiates, everyone does whatever they do.
Right.
And it's just the way this works, right? I mean, conceptually, it's like an arm's length deal, but this is a special situation because the company was in play and the company was, and this is the kinds of things they do all the time. There's a change of control. Here, they're enforcing the change of control. Usually they're resisting the change of control.
Correct.
Right? I mean, usually they're on the other side of these things. Now, maybe that's going to be their argument that once they align themselves with Twitter, they effectively were on the other side of the street and that cost them something in terms of credibility in the future. But that seems pretty much a reach to me as well, right? To some degree.
No, and by the way, they have denominated the outcome as success. They won because Musk did close the deal on those terms. So, I don't see the contingency argument being very good. As far as the unclean hands argument, it doesn't quite work. They could say if Musk hadn't been such a putz, we wouldn't have had this case in the first place.
Right.
But that is not a good excuse for stealing money or violating all the professional rules, which they did.
Yeah, I mean, I wondered, and this is the question I had for you, which is, let's say they came to you, and this could be the wrap-up question, because I know you've got things to do tonight, and we can pick this up after we see what procedural maneuvers they do. But let's say they came to you, because you're the expert on fiduciary duty, and they said, look, Wachtell, we have an issue. We have a fee agreement. We want to figure this out early in the relationship. We just got this fee agreement signed. It's kind of our standard agreement, but Twitter tweaked it a little bit. We would have rather had New York law. We would rather have New York negotiation. We would rather have this. We'd rather have that. This is the master retention agreement. It's on Twitter's letterhead. They sent it to us. We're signing it in New York. Maybe it's viewed as accepted in New York versus accepted in California. But under California law, as a fiduciary duty expert, you wrote the treatise. We signed this in June. We want to get, if we win, we want to get a success fee that's more than our hourly rate. And we want to charge full hourly rates, and we want to be paid upfront as much as possible, because we don't know if we'll ever get paid if Musk somehow wins and then holds us up. So tell us what we should do in our fee agreement to have an enforceable deal. We're going to be putting arbitration and a bunch of stuff in it, but we're worried the California courts may not be as nice to us as the New York courts have been in approving our fees, and the Delaware courts too. Twitter absolutely won't agree to Delaware. They won't agree to New York. So we're kind of stuck with California. So under California law, what should we do differently? What would you have said to them?
Well, I would have made sure that independent counsel reviewed their new proposal and approved it before it became binding. That's one thing.
Mm-hmm.
I would have made sure that they had full disclosure to the client of what the range of possible outcomes would be. Well, that's another thing about this fee. 90 million was a fixed number. It wasn't a percentage of the outcome.
Right.
And that has two aspects to it. One aspect is it eliminates all contingency calculations. The other aspect is it is a disclosure to the client, and the client was able to evaluate it.
Right.
On day one. So I think the main thing I would have done is approval by a third-party counsel. And that would have protected it, in my opinion, after discussions and meetings,
But you would have said they had to actually define the success fee in a way that was far more specific than some sort of discretionary, this is just what we expect and want. And if you don't pay it, we're going to be really sore with you. Because I suppose Twitter could have said, it's outrageous, we're not going to pay it. They've got the "oh my God" quote from one of the directors.
I saw that.
I mean, oh my God, like we never knew that we'd be paying that large of a fee. Because let's face it, for a company that was in financial trouble, that's a big hit against their bank account.
But that director approved it.
I know. It's almost like, why didn't someone stand up and say, wait a minute, I think we need to get an outside counsel or some critical person to give this some critical review.
Or, by the way, they could have simply said to Wachtell, look, we have an agreement. You're getting hourly rates. You've already earned $18 million in 3 months. It's enough. Have a nice day.
Right.
And if you argue about
it's enough, have a nice day. And if you really want to try to enforce this, go to it. But we're not going to be subject to the potential of litigation that we breached our fiduciary duty. And maybe you could have said, maybe, well, here's what we'll do. We'll put half of the money in escrow, and we'll let some third-party expert on what's a reasonable legal fee for the amount and quality of the work you did. We're happy with the outcome.
Right.
But the truth is there probably was less than 50 hours of in-court time. Like if you really look at the number of hearings in the case, and she ran, the chief judge of that court ran the case pretty quickly. I think there was less than 50 hours. Most of it was on Zoom. It wasn't even done. It was still in the technical pandemic. 50 hours of in-court time is a very small amount of time for a case that had obviously billions at stake. And of course, if you're that judge, if you're any judge, most judges get paid, including Supreme Court justices, less than $300,000 a year.
Right.
San Francisco Superior Court, I think it's under $220,000 a year. I mean, it's like they work 2,000 plus hours a year. They get paid, a reasonable hourly rate, I suppose you could say, but it's nowhere near $122,000 an hour, or even near $1,000 an hour, which most of their partners are billing at over $1,000 an hour. Right?
I think it was ridiculous, and I'm going to be very interested to see the initial motions and judicial response.
Well, let's stay tuned with each other on this, because to me, you are the expert, and I have to say, I always resort to thinking of you whenever I see a fiduciary problem. I immediately think, hey, what would Raphael say about it? I do that before I even go to your treatise. Of course, your treatise typically has the answer. Anyone listening to this podcast should know the law of fiduciary duty is the treatise to buy from Raphael Chodos. It's available online. You can go find it. It's also available electronically. I use both. I think it's the best thing in the world, and you keep it up to date. So I have to tell you, Raphael, congratulations. Of course, maybe I should send a copy of the podcast with a copy of your treatise to Wachtell as a gift. And just instead of saying them, enjoy. We've given you some free time thinking about your case, and we're watching it, and it's educational, and I'm sure it's going to be studied in law schools, and it's got to be part of your treatise at some point. I'm sure you're going to brief it. Right?
I have to look at my treatise to see how it deals with this problem. I'm right now focusing on ERISA. The ERISA fiduciary, there's been a recent case in there, and I need to add this section to my book, but let's think about this and reconnect.
All right. Thanks, Raphael. Have a good time. Talk to you later.
You too.
Bye-bye.
Tune in next time on The Valley Current.